My Lady Chief Justice, my Lady Deputy Chief Justice, the President of KEG, and KEG is not the GIA, it is the Editors Guild, the immediate past President, my brother Linus Kakai, members of the Council, and members of the Guild. Thank you very much for inviting us to this very important function. And I stand here, but then thank you, Dilo. We have quorum from the north as we speak. So don't think we are just a minority anymore. Two are enough to form quorum. I stand as the chairman of the Communication Advisory Committee of the Judiciary, which is the link between the judiciary and the media. And when I was called yesterday to come and join you in this forum, I was asked to respond to any questions that may be raised by prior speakers and now the President and immediate past President. But before I do so, and before I invite the Deputy Chief Justice to invite the Chief Justice, let me say three quick things which came to my mind when I received the invitation. The first is to thank you, the media, for the work that you do. Oftentimes, when we look at professions, we look at what we do in this country, we directly call you for the state, as if what you do is peripheral, it's inconsequential. But we know that in any democracy today, the media is an amazingly strong watchdog for good governance in any country. And so we thank you for the work you do, and take it from us in the judiciary, we appreciate you. Number two, while we have received a number of concerns from the President and immediate past President, I will only address initially three issues which are concerns from our part. Number one is objectivity in reporting. The judiciary suffers a lot from this because when you report in a manner that does not express what a judge or magistrate has said, the result is that the public out there gets the wrong information and is not able to relate with the decision made. So be objective even as you balance what you report. Number two, we must recall the history of both the judiciary and the media in the 2007-2008 election. Both the media and the judiciary suffered attacks from the political class because one, they said the media was not objective, and two, the judiciary had no capacity, had no independence, had bias towards certain sides, and therefore no case could be brought to court. And we fought as a people. So that even as we go to 2022, we as a judiciary and you as a media must remember that sad history and do our work in a manner that does not either create the flare of violence nor create perceptions of bias on your part. And we shall do our best to not to have that perception. Number three, when I was at the High Court and I was able to relate with Gilo, Roslyn, Jim Chapia, and others, I realized that there was no mode of communication between our court reporters and the judiciary. And yet our communication department is extricated from what I do as a judge. So they wouldn't even know what I wrote, what I delivered this morning. And that was the reason I thought that we should create the Kenya Court Reporters Association. And the intention was that that Court Reporters Association will also have a connectivity with the Judicial Training Institute, then, now the Kenya Judicial Academy, where court reporters can get some training in law. And now that we have an academy which is going to offer at some point diplomas and degrees, why don't we begin a conversation today where journalists who do court reporting can be trained and even attain diplomas in law? Because that is a manner in which we can have you we can have, you have journalistic training, but because you're doing a lot of legalese, you have basic training in law. So when I spoke to one of the members this morning on my way here, he said, tuko na shida indani, which means that internally there, misukosuko, a very Kenyan thing. You form an association with a good idea, but local politics enters. Tribal politics too. So, Mr. President, I am now, because you know I'm a judge, I do not beg you to do. I now direct you to do. To call upon these members, these court reporters from all the media houses, tell them to revive that association. I am the patron. I am available anytime to have a meeting with them and to talk to JTA, KJA, and Dr. Frida is here from the academy, Judicial Academy. We can create a curriculum immediately where we can train our colleagues in the media. The Chief Justice has a robust speech, I'm sure, but let me, Chief Justice, because that was what I was supposed to do, let me respond some of the issues raised by both Churchill and Venus Kaikai. The first one is on the question of independence of the media and independence of the judiciary. We don't need to be told more than we did. It is our duty to remain independent against all forces. So both you and ourselves must remain independent, and that's what we can do. Number two, on the defamation cases that Churchill raised, those from the Standard Media Group will remember that about 10 years ago, I held a series of trainings in this hotel. And I spoke to you about defamation. And after those trainings, the number of mistakes made by journalists tending towards defamation reduced in the Standard Media House. You, Gilo, remember that at the start, I had conversations with William Pike and Paul Ilado on how to manage your conversation around defamation. But now, because we have a brave new media, like the brave new bar, I'm seeing more and more mistakes being made by untrained journalists in the area of defamation. Mr. President, once again, why don't you begin a conversation where judges, magistrates can have a conversation with you and train you on the rules of defamation, and then we're able to relate at a more formal professional level. Number two, again, I will request you, Mr. President, to contact Frida Gidhiru, and so that when we have the judges colloquium, and we have many meetings of all the courts, especially the High Court and the magistracy, we can have a speech by you, by Venus, by whoever else, where you can raise your concerns, so that you can tell us what is it that we are doing that you think that the judgments are overly exorbitant. If you remember, many years ago, at one point the judgments were capped at 30 million after the Biwott case. When we had the Gisheru case, they came down to 10 million. When I did the Obure case, I did 15 million. I think we need to have that conversation with you where you can tell us, this is the analysis we have had, there is no consistency. Incoherence in judgments is unfair to the people we serve, and we as the judiciary must be told you are being unfair. So let's have that conversation. And lastly, please share the analysis you have with the Honorable the Chief Justice, so that internally we can have that conversation. Linus, you raised a question of, no, I think it was Churchill, overreaching. One of the threats to any democracy is where the media and the judiciary receive these things. While the judiciary has been spoken about for years on end about corruption, what about yourselves? Don't journalists receive brown envelopes? Don't media houses receive money to do certain stories in a particular way? Those who know about the case I threatened to file against the Standard, but which the Deputy Chief Justice finally filed, will remember the story. And those in Star and the Nation will remember how that guy brought that fake story that Isaac Lenaola of Secretary Village was communicating with people on the other side during the petition. It was very offensive, but a story was done by the Standard. It was offensive to me as an intellectual and as a judge, and I took action. So you too must retain that independence and avoid the temptation to be told, we want to fix Lenaola, so you run a story on page 3. Thank God, stand alone apology on page 1. And I stand with my integrity. So I think we need to be careful also. We don't give ourselves the opportunity for those people to reach out to us. That is both for us as judges and for you as the media. And of course, use the Media Council and other mechanisms to punish those who are errant. Linus, the 2013 decision of the Supreme Court and the two 2017 decisions speak for themselves. And I think we must continue having a conversation with ourselves as a country and how to ensure that the independence of the institutions that we hold dear should never be compromised, no matter the circumstances. And so those decisions speak for themselves, I will leave it at that. The question of appointment of judges, that's a matter for the Chief Justice as the chair of the JSC. Chief Justice, I will leave it to you. But I must speak about defiance of court orders. And on this one, I will not blame even the parties that defy the court orders. I must blame ourselves. We have sufficient mechanisms to punish errant parties. Why are we as judges not punishing parties properly? When I was at the High Court, I did make an order against a certain gentleman of repute. And after that, that gentleman has never spoken about court orders again. So that we ourselves must point fingers at ourselves and say, why don't we punish them? Why are judges fearful of sending people off for contempt of court? So, while you must continue telling us we are doing wrong, while you must continue telling errant parties they are doing wrong, please point fingers at us too. We must confess that. And in all my speeches to my colleagues, I keep saying, do not fear to put anyone in for contempt of court. Even a slap on the wrist is worse than nothing. On the petitions and technicalities, you know, before 2010, the precedent set by the Court of Appeal was that personal service is mandatory. Now, if you're sitting in the High Court, like myself and my sisters, in some station out in Meru or Machakos or Kakamega, you must follow that precedent. But 2010, this constitution said that 159, you shall not use technicalities in doing justice. So any court that uses technicalities now is not only flouting and breaching the Constitution, but should be punished for doing so. Because technicalities are no longer. And we put these things, I was saying, some of you are here. We put this specifically because of those cases where technicalities were being used to avoid justice. Today, no one can say that I can use a technicality to avoid the justice. Lastly, Chief Justice and colleagues, on the logistical questions which Linus has raised, I thought to myself that during the BBI hearing, we had a good arrangement in the COVID situation we are in. And should there be any issue, that is my work, and that's the docket the Chief Justice has given me. If there's an issue around how we handled you as a media during the BBI case, which was, by the way, a test run for us for the big one out during the election. So if there are any issues, Mr. President and your council, let me know. Let the Registrar of the High Court know. Let the Chief Registrar know, and we shall manage the logistics. I didn't see any problem myself. I thought we did well in the last case. So in conclusion, Chief Justice and colleagues, I hope that you shall meet your expectations as a judiciary. I hope that you will meet our expectations as the media. But we are in this situation where we must work together to bend them to see bend. So whether you don't like my face, or you like it, or you don't like my face on the headline or on page 3, we have to work together. Whether you like the Chief Justice or not, you must report fairly about the Chief Justice. Whether you don't like Philomena Mbedewa Mwilu, you must report fairly about it. So let us have that respect, that camaraderie, that friendship, that togetherness. And that, the only way we can build our two institutions to the level Kenyans want. As I see it, you know, when Lenas was speaking here, and throwing all those Latin phrases and quoting cases, I told myself that going to school of law is a very good thing. And so for those that have aspired to do law, like Rosemary Obala here, umesema look away. Sasa unakaa tunde. Those who want to have the feeling of both professions. Lena is a good example, and congratulations my brother for that. I thank you all. On that very happy note, I must now take my proper place in the judiciary and humbly call upon the Deputy Chief Justice, the Honorable Philomena Mbetewa Amwilu, to come and make her remarks and invite the Chief Justice. Karibu, Deputy Chief Justice.